Hello, friends. Good evening, everyone, and I welcome all the participants, and I welcome Deepak Sharma ji in our today's session. And friends, our today's topic is on CFSS. We will do detailed discussion of CFSS 2020 scheme, which MC has announced a few days back during COVID time. The scheme was announced. So CFSS 2020 and critical aspects of companies Act 2013 we will discuss in our today's session. And today we have CS Deepak Sharma ji, who is a renowned company secretary. And sir is having more than 20 years of experience, and he is a practicing company secretary. Has taken more than 300 webinars, and sir is from the Delhi. And now I will request sir to start his discussion. And before going that, just let me give you update on our upcoming webinars. Our upcoming webinar is on tomorrow. Day after tomorrow, we have session on ICI Code of Ethics, ICI New Code of Ethics, I would say that, which will be taken by ICI past President C. Amarjit Chopra ji. And Sunday, we have session on ITC, which will be at 12 p.m. So link of the same I will share in the chat box as well as in the description as well. You can join these both sessions. And we are starting one Excel series, 6 days Excel certification course from 25th from the 6:30 to 8:30 for 6 days. You can join that as well. Link of the same also we will share in the chat box and the description. Now I request you please subscribe our channel as well and like this video as well. Now over to you, Deepak ji.
Thank you so much. I think a lot of disturbances there. Deepak ji, can you now?
Yes, sir.
Am I audible now?
Yes, you're audible.
Some background disturbances there, I believe.
I think let me stop your computer mic and then you can continue with the phone mic. Will it work?
Sure. Why not?
Now try from the phone mic. Yes, now
Is it
it's
okay
fine.
now?
There is no disturbance now.
Deepak, hello.
There is some voice disturbance. We are starting soon. Just give us 1 minute. Deepak ji is connecting soon.
Yeah, Deepak ji, am I audible now?
Yes, sir, you're audible.
आपकी आवाज नहीं आ रही है मुझे.
मेरी आवाज नहीं आ रही है?
Okay, so thank you so much, Studycafe, and Deepak ji, what brilliant work you have been doing in this pandemic time. Thank you so much for inviting me to this program, actually, which is need of the hour. In fact, let me brief about the concept, what Deepak ji was just trying to give to the stakeholders. I just discussed this topic with CA Deepak Gupta ji, and he was passionate to provide a sort of technical knowledge to the participants so that they may just, have a practical aspect and practical outlook of the subject as well. I have prepared my PPT in a way that you will come to know what the modalities are there in this program, and how to take the benefit and maximum benefit out of this new scheme, CFSS scheme. We will touch upon certain other technical aspects recently introduced by the Ministry of Corporate Affairs. And Ministry of Corporate Affairs has come out with many modifications and amendments in the recent past. And in the recent past, we have witnessed, I think, number of notifications and circulars with regard to the development in the company sector, which is really important to note down and just to follow in the right spirit. Uh, in fact, I when study corporate law, so a lot of technical work is required as far as intimation to the various authorities and regulators is concerned. So, Deepak ji, I would like to take my stakeholder to a practical perspective where they can learn how to take the maximum benefit out of this CFSS scheme. Second, just to avoid any sort of a technical mistakes and petty mistakes, what they should keep in mind, and what is the objectivity of the Ministry of Corporate Affairs in reframing the companies in 2013. Our company sector is now more than 7 years old actually, and we are matured enough to understand the pitfalls of each and every provisions of the companies like 2013. The Ministry of Corporate Affairs has also understood that criminalization of any statute will not serve the purpose. Therefore, Ministry of Corporate Affairs has come out more than 2 times, and recently the Companies Amendment Bill 2020 is pending before the Parliament for its approval. When you go through the suggested provisions of this bill, Companies Amendment 2020 bill, you will find that a lot of decriminalization of the present section now is on the reel. So, with your approval insights, I would share my screen just for your benefit.
So screen is visible, sir. So we need to open the PPT. Now it's visible.
Deepakji, is it now visible now?
Yes, yes.
Perfect. So now this is something in fact when you just say that yes, the companies start fresh start scheme, so we have to go to the introduction part, which is really important, my dear friends. As a stakeholder, as a chartered accountant, as a company secretary, we all have our own capacities. We have own our resources. But yes, whenever you just find that yes, there are certain schemes, there are certain new amendments in the Companies Act 2020 to track those companies act provisions is really important. And when I say really important, because to cope up with that and to just follow the amendments, it is the intention of the Ministry of Corporate Affairs, and they expect from the stakeholders like chartered accountants, the company secretaries like us, and other professional class. Ministry of Company Affairs has issued one circular, which is dated 24th of March 2020. And my dear friend, this particular circular is important in a way that during the pandemic time, this is fortunately the day, just a day when pandemic situation globally just was created, and we have been just witnessing a lot of hardship on our head. But before that, Ministry of Corporate Affairs was getting many representation from the professional bodies to just give one last chance so that existing companies can just have sort of a uh, just some sort of a relief actually, in a way that they should comply the law in the right spirit and in the right body. So
Deepak ji,
whenever
sir,
social
abhi,
measures
hello,
which provided in view of this COVID-19 pandemic,
hello.
it indicated that it provide immunity to the companies and LLPs both, and with respect to the delayed filing of e-forms. Whenever you will look at the e-forms, So around 78 e-form have been notified. And when you file and when you find or when you just go through the ministry site, you will find 10 forms are dedicated to the LLP. Around 12 forms are related to LLP, 10 forms are related to Companies Act 1956, and rest of the forms are for Companies Act 2013. Now, in this furtherance of the same, the company's fresh start scheme, which is in
Deepak
short
ji, hello.
CFSS scheme,
Uh,
it has been rolled out, and it was a given time that from 30th March 2020, it will be just notified to be active, and it will active from 1st April 2020, and it will remain active till 30th September 2020. Now, this is the time when a stakeholder would like to clean the slate, and in a way that yes, it will clean the slate of non-compliances. However, CFSs apparently, when you look at the circular, when you go through the circular, you will find that it is not rolled out as a measure just because of COVID-19. Because when you recall 24th of March, you were not aware that we will be under lockdown for a substantial time. Actually, initially we were just thinking that it would be a 20 days or 30 days a picture of COVID, but now it is delaying. So it means it was sort of a amnesty scheme which ministry would from you know yeah, hello.
हाँ दीपक जी, दो चीज़ थी। एक तो मेरी आवाज़ शायद आपको जा नहीं पा रही है, इसलिए मैं बोल रहा था, आपको सुन नहीं पा रहा था। पार्टिसिपेंट्स आर सेइंग कि थोड़ा सा धीरे जाने के लिए बोल रहे हैं, मैसेजेस आ रहे हैं मेरे पास चैट बॉक्स में। सेकेंडली, आपकी वॉइस क्लियर नहीं आ रही है उसमें। हाँ, उसमें काफ़ी डिस्टर्बेंस आ रहा है। हाँ, तो आप यहाँ से बंद कर दूँ मैं, और लैपटॉप वाले से आप बोल के देखिए अभी।
मैं करके देखता हूँ उसे।
नाउ यू कैन स्पीक।
Yeah, please.
हेलो।
Yeah. So, in fact, if my voice is not clear, so I'm just taking the other way out if possible. Deepak ji, will you just help me in that, just to understand if some difficulty is there?
Now it's clear, sir. Now it's better, better than previous one. So now you can share screen if you want me
Yeah.
to share screen.
Am I audible now?
Yes, you're audible now. You need to mute
Deepak
mic
ji,
from the mobile. Mobile, you need to mute.
am I audible? Am I audible, Deepak ji?
Yes, yes. You're audible, audible.
Deepak ji, am I audible now?
Yes, sir. Yes, sir.
Perfect, perfect. Perfect. Thank you so much now. So, my dear friends, this would be called as a amnesty scheme. Why? Because this is not apparently rolled out as a measure of COVID-19. So, it means that all the filing related to the compliance under the provision of the Companies Act 2013 are basically what the objective of the Ministry of Corporate Affairs and Ms. MCA was working well before 24th of March 2013. So, you have to understand that yes, this is the amnesty scheme which all of us would take it as a measure actually. Now, what was the need to have it actually? It was needed. Why? Because to reduce the compliance burden on the companies. When I ask about to reduce the compliance burden on the companies, then you will find, my dear friends, that in 2016, 17, 18, and 19, during the last 4-5 years, we have witnessed a lot of shell companies which have gone closed actually, and government of India has a hard shut on those categories of companies. Lakhs and lakhs of directors have become disqualified under the provision of Section 164. A lot of companies were not able to cope up and to just match with the Companies Act provision 2013. Therefore, a lot of non-compliances were there in terms of pending filing. So it will reduce the compliance burden on the companies. Second is to clear all the non-compliances on account of non-filings. Now, most of the private limited companies, why? Because when you look at the data which has been provided on the MC side,
you will find that around 80 to 90% of the companies are basically private companies. They are the small companies, and you will not find any sort of a relief for them how and when they will just clean the slate actually. Third, when you look at the penalty, the penalty has increased manifold. The moment you cross 90 days, that is 90, you will find that government has imposed a heavy penalty on this actually. Now in fact, whenever you find this way just to have a clean slate of your compliances, you will also find that recently the annual filing has become a bitter toast actually. Why? Because a penalty of rupees 100 per day was there. Look at an example. Whenever a company having a share capital of rupees 1 lakh just forgot, or maybe due to negligent act or whatever way, if they have forgotten to file their annual filing, they will have to file it maybe 1 year down the line. Then how much money they will have to pay for filing the balance sheet and the annual return? They have at least to pay 75,000 bucks. So it was the time just to save the energy. Third is, when the government is promoting MSME sector, and they find that yes, some sort of a relief for the small entity must be provided, then in a way that yes, this is the time, this is the right time when the companies which have been revived, which have been there just due to compliances, they are not active, so let's them give them a better chance to comply actually. So this was the need for CFSS. Now it will also allow the companies a one-time opportunity to complete all the pending compliances. It will also give waiver of additional fee for late filing, so there would not be any additional fees whatsoever, in a way that no additional fees or penalty shall be imposed if a company takes the benefit of CFSS and file all the pending document as provided in the schemes within that stipulated time. CFSS also provide immunity to the defaulting companies from any prosecutions or proceedings. This is the future prosecution. This is the future proceedings for the penalty imposed or to be imposed on account of delay in filing. My dear friends, when you look at this is really a good chance. It's a golden chance for you guys as a stakeholder, that you should definitely take the maximum benefit of this particular scheme. My dear friends, I just take you to some historic schemes actually. So far, Ministry of Corporate Affairs has come out with a lot of schemes for the benefit of the stakeholders. I may be having some questions that what fault the compliant company has done. The government has to think progressively actually. So whenever the government thinks progressively in the best interest of small companies, so they will have to sort out some sort of a amnesty scheme like this. When you look at this tree, my dear friends, so I just take you back to Companies Act 1926. uh, in fact, I have been the student of Companies Act 1926 so well that yes, we can just have a idea that what Companies Act 1926 provided at the time of when a few of the amnesty schemes were introduced at that point of time, and what's the difference this present scheme has made when the MCA has come out with the CFS 2020. So when you look at this tree, you will find that CLSS Company Law Settlement Scheme 2011 was there. CLSS via this circular number 59 2011 was there, and CLSS a waiver of 75% of additional fees was there. When you look at the left side, my dear friends, you will find that when the last scheme was there under the era of Companies Act 1956, at that point of time, the CLSS wanted to have the 75% of the additional fee as a waiver. Now look at the difference. What CFSS why this circular has provided to you in comparison to the previous so many CLSS schemes were there. So this time, entire waiver of the additional fees has been provided in the scheme. So you can have a good taste to have this CFSS under your pocket to comply the pendency of your clients actually. My dear friends, when I study corporate law, I have to study a lot of schemes being provided, a lot of amendments being provided by the Ministry of Corporate Affairs from time to time. I recall when after 2011, just after the activation of the Companies Act 2013. In 2014, again, the ministry provided the same sort of a relief to the stakeholder, and it also waived the 75% of additional fees. It means the difference is that at that point of time, the 25% of the additional fees was required to be paid under the CLSS. But now, under CFSS, no additional fees at all has to be paid, has to be given, and the same relief as would have been under the era of Companies Act 1996. So this is the difference between the CLSS under Companies Act 1996 or CFSS under the Companies Act 2013. Now recall 2018, when condonation of delay was again given, and it was informed to the stakeholder that sort of a relief to the defaulting shareholder, to the shareholders who have been disqualified, will not be applicable if they just file their document. Rupees 30,000 fees was imposed in 2018 as well. So what a good scheme this is, CFSS. There no penalty additional fees is there, right? So you have to take the benefit of this scheme, and this is the right way and a good opportunity to clean the slate, what the circular suggests actually regarding this. My dear friends, this will be applicable as far as the applicability is concerned to all the defaulting companies. Defaulting companies has been just mentioned in the Companies Act 2013, which have defaulted in filing of their document, information, return, or annual statutory filing. They have just forgot. So whenever this disqualified company is there, this defaulting company is there, you will find that any document statement returns you have forgotten to file, now take the benefit of CFSS under this MC21 registry. My dear friends, if you look at this scheme, so this scheme is not going to be applicable on certain categories of companies. So companies against which final notice for striking of the name has already been initiated by the adjudicating authority or the regulator. Companies which have voluntarily filed application for striking of the name of their company, companies which have been amalgamated, or companies applied for dormant status under the provision of section 455 of the Companies Act, all the vanishing companies. When you look at the vanishing companies, so vanishing companies has not been defined in the Companies Act, but SEBI has defined this word. The companies whose promoters or directors are not traceable, the registered office is not traceable, and since last 2 years they have not filed their balance sheet and annual return. So this is the sort of a definition of a vanishing company. You cannot take the benefit under this CFSS scheme if you are covered in any of the non-applicable status of the companies as provided in this circular. My dear friends, this is the glimpses of e-forms which have been provided in so well structured way that 78 total e-forms have been notified. And when you look at the form, they are into different categories. They are into annual filing related forms. They are resolutions related forms. They are directors related forms. They are auditors related forms, and they are miscellaneous form. When you look at the structure of the form, you will find that 10 forms are dedicated to the Companies Act 1956, 12 forms are dedicated to the LLPs, and rest of the forms are dedicated to the Companies Act 2013. Under these categories, main forms are AOC, AOCX, BRL, consolidation, auditors related forms, ADTs, MGD 14 form. When you look at section 117, read with section 179, you will find a lot of compliances and a lot of provision which cover filing of form number MGD 14 at that point of time. Under section 186, 185, whenever you are going to have some sort of a approval before the shareholder, you have to file this form maybe prior to the corporate event or maybe post corporate event actually. When you look at the director rated form, you will file that yes, DIR 11, DIR 12, and DIR 3C and DIR 3 KYC. This is something important. Why? Because when their 3 KYC was introduced, it was not having any fee. But later on, a fee of rupees 5,000 per director was imposed. So when you file under this CFSS scheme, no fee may be charged by the ROC on this, and this form again will be free for you. Auditor rated form, all ADT 1, ADT 2, 3, and 4 are well covered under this CFSS scheme, my dear friends. Now, for the foreign companies, rated forms, FC1, 2, 3, 4 have been provided over here. It means clearly that CFSS is applicable on the foreign companies and foreign entities as well. Why? Because all the forms related to the foreign entities have already been covered under this circular, under this CFSS scheme as well. All the forms related to IPF related, if you have forgotten, they are well covered. INC, for example, INC 22 or INC 22A. So when you look at INC 22A, this is a one-time form, and it was having zero fees, but later on a rupees 10,000 fees was imposed on this also. When you file again this form for the registration of the registered office with photographs of the directors, other credential of the directors, and the longitude and latitude of the registered office, you will find that these forms are now well covered under the CFS 2020. Therefore, you may not be charged for that form also. So these two zero fees, which became 5,000 fees or 10,000 fees forms later on, now again becomes zero fees attracted forms. My dear friends, these are the e-forms which definitely must be in your pendency list. So before going further, as a practitioner, I can just advise you on personal level that your each and every client file must be sorted out in a way, it should be vetted in a way, and there should be an internal due diligence process to be completed by your good self, by your team, so that if any of your client has forgotten or has not filed any of the e-forms related to Companies Act 1956 or 2013, this is the best time you can file it, and you can just have a credential, a solid credential before your client. My dear friends, these are some of the important e-forms, the analysis which has been just provided over here. This is something very important. Why? Because you have to have a general sense of understanding that yes, Companies Act 2013 provides every timeline with every form and with every compliances. Within that stipulated time, if you have not filed it, it is attracting additional fees. And this is what makes the difference actually under this scheme. So AOC form or AOC consolidated form, my dear friends, if filing of annual financial statement of the company is there for the purpose, so it is meant that under section 137, some timeline of 30 days from the date of annual general meeting has been provided, and you have to file within that stipulated time. If you have not, still not, then 100 rupees per day. And if the nature is repetitive, then 200 rupees per day, the additional fees can be charged. This is a very heavy duty. Just, you forget to file it for 30 days, additional fees of 3,000 shall be charged actually. Now under the CFSS, no additional fees whatsoever is proposed to be charged, and otherwise also immunity will be provided to you. MJD 7, these are the important form, my dear sir. Why I'm just covering it for your benefit. It is for the purpose of annual return, and under section 92, it has to be filed within 60 days from the date of annual general meeting. MJD 14, this is for the purpose of filing certain resolutions, agreements, contracts, and other stuff, the information with the registrar as a prior intimation or as a post intimation. It is to be filed within 30 days from the date of board meeting or the general meeting, unless a specific section talks about. This is section 117 is there, and when you forget, then condonation has to be sought from the Ministry of Corporate Affairs by filing that application in that respect. There are 3 KYC or WAP KYC has to be there. It was the effective till 14th of October 2019. Thereafter, these forms became fee attracted forms. So now under the scheme, no fee shall be charged. INC 22A, it is was the active form. Whether your company is active or not, file it by giving a lot of information about the company secretary's appointment, CFO appointment, auditor's appointment, longitude, latitude, a director sitting in the office premises, director standing outside the office with the signboard of the company with the name, SIN number, and listed office of the company. So many other informations they were supposed to be attest with that particular form INC 22A, my dear friends. It was also could have been filed before or on or before 15th of June 2019. 881. This is very important for you guys as a chartered accountant. This is for the purpose of appointment of auditor. Intimation has to be given to the to the register of companies, which has got the power to take it on record. So it is within 15 days from the date of annual general meeting. This is something very important. Why? Because these are the very general sort of e-forms, and maybe casually, maybe sometime deliberately, we just forget to comply one or two forms. Here is the chance when you can tick it. Now, my dear friends, this is the particular e-form which is not covered under this CFSS scheme 2020. Why? Because the government has just given some sort of a clarification. The ministry people were just discussing this very important part, that these forms are related to a company which is progressive in nature. If company is filing a charge, it means that is progressive. If company is filing increase in the capital of the company, it means company is progressive. So all the charge forms, either CSG1, CSG2, CSG4, CSG8, etc., are not covered in that. And for the purpose of filing these forms, you have to take the approval route for the purpose of getting it condoned actually before the appropriate authority. Now, increase in the authorized share capital, SS7, this form is also not covered under this particular scheme of CFSS 2020. So please take a note that the forms related to the charges and the authorized share capital increase are not covered under this actually. Now, cases where immunity of this scheme is not applicable. It means, despite of the fact you take the route of this, but this immunity certificate shall not be provided. Let me share something about immunity certificate. After this scheme will get over on 30th September 2020, effective from 1st October, once CFS 2020 form shall be deployed on the Ministry of Corporate Affairs site, you will, incorporate all the SRA numbers of all the details of your filing under CFS 2020, and this is a fee-less form. It means no fee whatever shall be charged on this particular form, and this will be a mandatory form. After the filing of this form, the Ministry of Corporate Affairs will issue a immunity certificate for the prospective prosecution with regard to filing only. Please underline this, for the purpose of filing only, and not about any non-compliances thereof. So here there are certain clauses which tells about that cases where immunity of this scheme is not applicable. Where any matter is pending before court of law, if any prosecution matter to the company is filing, then this scheme will not be applicable. In case of management dispute of a company pending before any court of law, or tribunal, if
Hello, hello.
amounting to management disputes, court has ordered conviction. Hello,
सर बीच बीच में आवाज जा रही थी आपकी. नाउ इट्स फाइन.
thank you. So, court has ordered conviction of any matter and no appeal preferred before the scheme. For example, if registrar of companies has adjudicated certain matter under the provision of section 206 of the Companies Act, and the conviction has been found, the additional duties or the penalty has been imposed by the register of companies, and the appeal has not been filed under section 465 of the Companies Act before the appropriate authority, that is the regional director, then this is not applicable. If you have filed an appeal, then you have to either withdraw the appeal or maybe just seek the approval of the appropriate authority, that is the regional director. If any order imposing penalty has been imposed and no appeal preferred before this scheme. So these are the instances, my dear friends, when this scheme immunity of this under the scheme will not be applicable. This is specifically mentioned in the under this scheme, my dear friends. Some special provisions for the cases where penalty order was passed and appeal could not be filed, as last date of filing the appeal falls between 1st March 2020 to 31st March 2020, both inclusive. Now take an example. You were given by the adjudicating authority or a court, your appeal period has started, but you have not filed the appeal under for that order actually, and that appeal time falls between 1st March 2020 till 31st March 2020. Then you will be given additional 120 days. It means over and above 31st May 2020, you will get more, more than 4 months time, 120 days time, or for the purpose of this actually. Now, my dear friends, this is something very important for you. Why? Because this period of additional 120 days shall be allowed from the last day of filing the appeal actually. So whatever the last day is, your 120 days will continue from that, not from 31st May 2020. It means when you fall between these 2 days, your appeal period is filed. So your 120 additional day time shall start. During additional period, no prosecution for the purpose of non-compliance pertaining to delay which is associated with filing of your belated returns or documents for the orders shall be initiated. It means that period is something for the purpose of taking the benefit of this scheme. File all the documents for the purpose of, for example, if ROC must have issued a notice for the purpose of non-filing of balance sheet and annual return for any financial year, an order has been passed by the ROC penalizing you actually, and you have not made any appeal before the regional director, then you have to file and or deposit the appropriate penalty what has been just mentioned in the order. If you have appealed, for example, your appeal period is falling between these 2 days, then again additional 120 days will be there, and whatever the non-compliance was, this is the best time you can just take the advantage. Now, how to take the benefit? What is the modus operandi under this scheme that you have to just take the benefit of this? My dear friends, to avail the benefit of this scheme, the application for obtaining immunity under the CFSS-2020, some application has to be made by filing e-form CFS-2020, as I informed you that this shall be deployed with effect from 1st October 2020. As per the draft immunity certificate which has been attached to the circular regarding this, dated 24th of March, the SRN number of the e-forms against which immunity is to be sought has to be mentioned. So you have to put each and every SRN of the e-form for which you have availed the benefit under this scheme. Accordingly, the scheme will require the defaulting companies to clear all their pending filings till 30th September 2020 by paying the normal fees only. Normal fees means whatever fees is applicable on your particular form, like 300, 400, 500. So once all the pending filings are made good, thereafter the companies shall have to file e-form CFSS 2020 within 6 months from the date of closure of the scheme. It means from 1st October 2020 till 30th March 2020, you will be 31st March 2020, you will be provided a time within which you can file your immunity form or the CFSS form, that is to get the benefit of immunity. Now, based on this immunity certificate, in respect of all the documents filed, it shall be the duty of the ministry office, the designated authority, to issue you a immunity certificate in this regard. Now you are relieved from all the prosecutions, whatever. Now let me tell you, my dear friends, when I talk about that only normal fees would be there, it means no additional duty would be there. And immunity certificate will also save you from the future prosecutions. But it does not mean that if you have non-complied any of the provisions of the Companies Act, then you will not be saved. You will be saved only to the extent the filing would have been delayed position for you. I take an example. Section 42 is there, which requires that a return of allotment has to be filed under PS3, and this return has to be filed within 15 days from the date of when you receive the money or you allot the shares. And until the time, this provisions say that until the time you file this, you cannot use the application money so collected for the purpose of any project or whatever. So if you have not done it and you have used the application money, so prosecution under section 42 for the purpose of non-compliance of that portion shall be applicable on you. But if you file PS 3 now under CFSS 3, CFSS 2020, then you'll be saved from the future non-compliance in relation to in relation to the pendency of filing of that e-form and the future prosecution, if any, might be there actually. So please keep in mind the non-compliance of the provisions of the Companies Act 2013 are at all not applicable. Now this only prosecutions with regard to filing, that if certain forms has to be filed within 30 days, you have not filed, the ministry has got all the powers to just penalize you, taking care of that. ROC has got ample power under section 206 to adjudicate matters and various matters under this actually. My dear friends, simultaneously LLP also got this opportunity. So this settlement scheme was introduced for them. Now LLP, as you all recall, it has been almost a decade when since LLP Act has come into being. The LLP is viewed as an alternate corporate business vehicle we have been using. It provides the benefit of limited liability, but allows its members the flexibility of organizing their internal structures as a partnership based on a mutual arrived agreement. So this is a more flexible vehicle actually as far as corporate entities are concerned. Owing to the flexibility, my dear friends, in its corporate structure and its is the operations, the LLP often become the preferred option for small enterprises. When I say enterprises, this is the small enterprises, and they are also can forget to file this any of the e-forms or whatever. The central government, in exercise of section 460, also extended this scheme to LLP White Gazette notification dated 30th January 2020. Now, the MC has decided to introduce a scheme, namely LLP Settlement Scheme 2020, by allowing a one-time condonation of delay in filing statutory required document with the registrar. This is something, and that is why 12 forms are also becoming the part of this CFS 2020. My dear friends, any defaulting LLP means LLP, and any defaulting LLP is permitted to file belated documents which were due for filing till 31st October 2019 in accordance with the provisions of this schemes. Now, e-forms which are covered are basically important. Then these are the important forms. Form number 3, which is related to information with regard to limited liability partnership agreement and changes, if any, made therein. Form number 4, notice of appointment or cessation, changes in name, address, designation of a designated partner or partner, and consent to become a partner or designated partner. And very frequently within your clients also, you may have witnessed that non-compliance from the side of the stakeholders. Now, form number 8, which is also important, statement of accounts. Now, this statement of account and solvency, which is called annual or interim, this form has to be filed with our Ministry of Corporate Affairs, that is ROC. Form number 11, annual return of limited liability partnership. This is also important. Now, why this is important? Because very often, the LLP were attracting a big dent on their compliance chart, and they were attracting huge penalty in terms of filing with the rest of companies. And this is the now golden time to clean the slate of the LLP as well. Now, my dear friends, this general circular, which is of 8th April 2020, is worth reading. Why? Because it provides a good opportunity to the LLP, and MCA has allowed companies to hold your AGM and EGM also. And this is a new feature, my dear friends. So whenever you look at the modus operandi to just conduct a meeting, you will find, my dear friends, that these circulars have provided you an opportunity to experience sort of a new corporate action through a technological advancement and in this pandemic time. So MCA has allowed extraordinary general meeting to be held through VC or OAVM method, which is complemented with e-voting system. E-voting, if you recall or call, under the provisions of the Companies Act 2013, you will find that all the listed companies or the such class of classification of classified companies which are having 1,000 or more than 1,000 shareholders, they can have, my dear friends, they can have means they can just opt for the electronic voting system. Now, this electronic voting system or facility has been simplified, voting through registered emails also, without requiring the shareholders to physically assemble at a common value. Now, some of the urgent nature of the businesses can be just considered over here. Now, this has been extended till 30th September. So, certain matters of urgent necessity, corporate action, like for example, you have to pass a special resolution for the purpose of getting some prior approval under section 186 for the purpose of intercorporate investments or loans. There is no way to have the physical meeting in this pandemic time. Therefore, Ministry has come out with this General Circular number 14/2020. So please take the benefit of this. And when you look at the modus operandi to do this, this is really practical in terms of drafting of the notice for the purpose of intimating the shareholders, registering their email, collecting the data of their email, circulating the notices through emails, now getting the response through email. So even small companies, small private companies, can have this mechanism of technology in terms of VC or OVM complemented meetings. So this circular is really important, and this is really critical. When I was just discussing this with Deepak Gupta ji also, Deepak ji also requested that many of you might have faced a lot of practical problem in terms of conducting meetings through this OVM VC method, where you conduct this meeting through VC or OVM. This is something very much different from the physical. Why? Because word is watching you actually. And in terms of education, you have to educate your directors, you have to educate your participants, then how to take participation in this meeting. A person who is not vulnerable to the technology, they may not opt for this. So anyone who can help them out to take the benefit under this circular, I think this is our duty as a profession to educate them so that this can be just done. But we are not avoiding any corporate action in terms of assembly, or that is physical assembly, and we can at all call a meeting through EGM. My dear friends, this circular is applicable to all types of companies, and it has been issued to facilitate to conduct the extraordinary general meeting and not the annual general meeting, my dear friends, of the company, but the ordinary business cannot be dealt through this circular. So as you recall, section 102 is clear, providing 4 types of ordinary businesses, like adoption of financial statement, declaring of dividend, appointment or reappointment of or ratification of the appointment of auditors, or appointment or reappointment of directors in place of a directors who are retiring by rotation. So So these are the matters which may not be the subject matter of the EGM at all. So other matters can be there and become the subject matter for deliberation among the shareholders, stakeholders by way of a video conferencing meeting to be taken care of under this circular. Now, all the matters which are considered to be unavoidable. So the second instance are unavoidable. This is emergency nature sort of a work actually, sort of a business. EGM must be held on or before June 30th, 2020. Now, this time has been just increased. Under this scheme, under this circular, for the EGM to be held, the facility has been provided for matters which are considered to be unavoidable. So the keyword is unavoidable, and you can take the benefit till 30th September 2020, my dear friends. Now, the effect of this is that you will require to file the resolutions. So all the resolutions passed in accordance with this mechanism shall be filed with the ROC within 60 days. So 60 days period has been there or clearly indicating therein with the mechanism, the proper mechanism which has provided that along with other provisions of the Act and rules made there under to be complied with during such meeting. So all the filings or e-filing has to be completed within 60 days from the date of such emergent EGM, which is the subject matter of this circular, my dear friends. Now, my dear friends, few FAQs are there with regard to all this actually. Let's have a look. Number one, and this is a question based, and you may have this question. This is a FAQ which MC has also published actually. So it goes like this. Is the CFS 2020 is applicable on foreign company? Will the forms FC1, 2, 3, 4 to be covered under the scheme? Answer is yes. Number two is how to file the belated returns for companies under liquidation. The companies which are under liquidation, so only refund forms like GNL2 under the provisions of section 149, 152, etc., INC 28 for the purpose of filing orders for amalgamation, merger, demergers, MGD 14 for the other class of compliances, and GNL 4, which is general in nature, are allowed to be filed if the company status is under liquidation. Now, question is, can deactivated director can activate through this scheme? So answer is yes, he can file DIR3 KYC, but please don't be confused in a way that this is not the thing with regard to section 164. I'm not talking about disqualified director who has become disqualified because of the provision of section 164 subsection 2, or he was supposed to vacate the office under section 167 of the Companies Act 2013. So when you call deactivated, so he has been deactivated in a two-way. His DIN number has been deactivated. You cannot use his DIN number for the purpose of appointment or resignation, and his digital signature has become ineffective or deactivated. So he can now take the benefit, and DI3 KYC form can be filed under this scheme. Should the return be filed for the subsidiary where its holding is currently under liquidation, but the return relates to the period where the holding had its normal business activities? So answer is yes. If the subsidiary company is required to file certain forms and is taking the benefit under the scheme, they can really take the benefit under this scheme as well, my dear friends. My dear friends, the next question comes whether CFSS scheme is applicable for the companies which have been automatically stuck off due to non-filing of annual documents, annual returns. Recall the list by way of Gazette notification when our Prime Minister or the Ministry of Corporate Affairs took very harsh steps on the companies which were not filing their legitimate balance sheet annual return. In one instance, lakhs and lakhs companies were stuck off from the register of companies register of companies. So the stuck off companies have to first approach to the National Company Law Tribunal and for the revival purposes under section 252 of the Companies Act. And when you approach the Honorable NCLT in this regard, you have to show why you want to revive your company. Is there any business? Is it really hampering the business? Is it having any asset? Is it having any charge? etc. So these are few things which you have to satisfy the honorable NCLT when you prepare application or the petition to be filed before the honorable NCLT for the purpose of revival under section 252 of the Companies Act. So before taking any benefit under CFS 2020, you have to approach NCLT, honorable NCLT, and take your company to NCLT for the purpose of revival if you have been struck off by the action of the ministry. uh, is CFS is applicable to the foreign companies having project offices in India? So answer is yes. CFS is applicable for foreign companies, which is providing this also. Uh, for filing MGT 14 or AOC 4, this is important form for the past year. Do we need to apply for condonation also? So for filing MGT 14 beyond 300 days, condonation is required. However, AOC 4 for the past years can be filed without condonation. So this is something a difference I want to just present before you, that MGT 14 is a very specific form and it is required to be complied under section 117, read with section 179 or other important sections like section 185, 186 or 188 or maybe 42 or 62 or any other section of the Companies Act which required the company to pass a special resolution or to just submit some contract or agreement with the Ministry of Corporate Affairs, that is Register of Companies. Now, if the company is in active mode but the directors then are deactivated, what should we do? So this is the question. So deactivated DIN for not filing the DIR 3 KYC can be activated by filing it now without the fee of rupees 5,000. So this is the benefit you can have it. If a company is having a sort of 4 directors, it can save 20,000. So during the currency of CFS 2020, provided such director is not disqualified under section 164 of the Companies Act 2013, because for the purpose of removal of the disqualification, one has to approach the honorable High Court of the respective jurisdiction in this regard. So my dear friends, this has to be kept in mind that there are 2 views, that disqualified director may not be opting this because of their disqualification, but deactivated directors can take the benefit of this. My dear friends, when company is an inactive company, like for example, when you look at the master data of the Ministry of Corporate Affairs, you find that yes, company is an inactive company. What will it do? The company has defaulted in filing a form number SS7, and it now wants to file SS7 under CFSS 2020. Can it do that under the scheme? So specifically, SS7 can be filed with applicable fee and additional fee. The additional fee waiver is not applicable for SS7 and charge related forms. So with additional fees, you can file it, but I can't assure you that prosecution may not be initiated against this form. So SS7 is not covered in CFS 2020. Now, one want to know that what are the list of e-forms which are eligible for additional fee waiver during the currency of CFS 2020 and LLP modified settlement scheme 2020. What I just provided you, the list of 78 forms is placed on the ministry website. You can just verify that certain forms are applicable for companies in 1996, 2013 and LLP. So 78 real terms forms are there. You can have it. Like for example, a return of allotment. You can file return of allotment under the provision of Companies in 2013, but return of allotment has not been provided for filing under the provisions of Companies in 1956. So this is something, a big difference. You can just have it after going through these forms which are available on the ministry website, my dear friends. Now, a company which has already filed MGT 7 but AOC 4 for any reason, for any year, is not filed, can it file now AOC 4 as well under the scheme? So answer is yes, you can file it. Now next question comes, for filing commencement of business form, which is really important form, which is confusing also at some point of time. A newly incorporated company now at additional 180 days is allowed, but which companies are allowed to such benefit. What is the cutoff dates for newly incorporated companies to companies incorporated from which date this benefit will get passed on or not? Answer is yes. All newly incorporated companies are required to file a declaration for commencement of business within 180 days of incorporation under Section 10A of the Companies Act, and initial period of 180 days and more 180 days time has been allowed for this compliance, and you can just have the experience of this circular of March 2020 also. So this additional period has been provided for the purpose of filing your commencement certificate and for procuring or obtaining commencement certificate from the registrar. In the case of company whose status as per MCA is active for filing, but whose all directors are disqualified, what I told you, what is the way out to avail the benefit of fresh starter scheme? So disqualification of directors cannot be cured under this scheme. But what I told you, if you can have the order from the respective high court in this regard, first get it and then just apply before the appropriate authority. Does the CFS 2020 allows refund of the late filing fee and penalty which are already paid on company filing made before March 2020? This is a really good question. Many stakeholders on many platform ask me that हमने क्या गलती की है जो हमसे ये एडिशनल फीस चार्ज की गई और हमें इस पे कवर नहीं किया. माय डियर फ्रेंड्स, मैं आपको इसमें बहुत इंपॉर्टेंटली बता दूं, एक क्वेश्चन बड़ा अच्छा है कि अभी तक अगर आपने एडिशनल फी पे कर दी है तो आपको फी वापस नहीं होने वाली, और आपको केवल एक टैग मिला है एज ए कंप्लायंट कंपनी का, राइट. सो आपको इम्यूनिटी सर्टिफिकेट की कभी जरूरत नहीं पड़ेगी. तो प्लीज टेक इट. द नो फी वेवर fee refund has been proposed for the previous stakeholder in this regard. So please make sure this. Now, is there any particular form for the purpose of CFS 2020 for the purpose of belated forms? Yes, CFS 2020 shall be deployed. If companies under NCLT and operations are managed by IP, whether he can opt under the scheme, so there is no bar. You can. So IP is always there to take care of the compliances. So company said is not stuck off, and if it is stuck off, it can take the benefit after it is revived. Under CFSS, form needs to be filed between 1st October to 31st March. Do we need to file any such form under LLP modified settlement scheme to get the immunity? So no such requirement of LLP who have availed the benefit under the LLP modified settlement scheme has been proposed, my dear friends. So this is what for the CFS 2020, my dear friends. Few more questions which are coming up actually for the purpose of benefit of you all. So in March 2018, take an example, Mr. X increased share capital but forgot to file the form SS7. Can he take the benefit of this same? So no, typically no. It is specifically stipulated in the scheme that this scheme will not be applicable in case of filing of form SS7 for the purpose of increase in share capital. Hence you will have to file the form with additional fees as applicable. My dear friends, in CFS 2020, one is asked to suggest whether it would be applicable to the project office of a company in India having FCRA number. So yes, it is applicable. Is the CFS 2020 applicable on foreign companies? Yes, it is applicable. What is the fee for filing the e-form CFS 2020? There is no fee. It is just a form to get the immunity certificate from the ROC, from the Ministry of Corporate Affairs. So no fees are proposed to be given, my dear friends. Now, what Deepak Gupta ji just urged, actually we were discussing this matter, and Deepak ji was very active in understanding the concept that what critical aspects we can share with the stakeholder and with the professions. And thank you, Deepak ji, to just give me that energy in a way that yes, we can just share that practical inputs of the critical analysis. Nowadays everyone is facing, every stakeholder, every profession is facing. So accordingly, what Deepak ji was requiring as a mentor to Studycafe, this is something really important to understand. Nowadays, what MC is considering in decriminalizing the provisions of the Companies Act 2013. CSR is one of the important factor nowadays. And when you look at November, our Finance Minister Sita Ramanji was addressing the Parliament and they impose some sort of a criminal action to be initiated against the category of companies which were not investing their CSR funds in a way which is covered under Schedule 7 to the Companies Act 2013. But after the representation of a lot of business houses, regulators, were forced back to take it back, and no criminal action was proposed thereafter. After that, ministry has come out with many of the provisions. In fact, I myself is a member of core committee of the Institute of Company Secretaries of India, which suggested to the Ministry of Corporate Affairs about the provisions which can be thought of for the purpose of decriminalizing it. Actually, it means there is no way the adjudicating authority like register of companies or the regional director at their forum can sort it out and can impose certain duties, and these companies may not be forced to be prosecuted and may be prosecuted in a way that compoundable or non-compoundable offenses which have been committed. So here non-compoundable offenses will remain as intact as they were. So whatever the compoundable offenses were there, now they have become only the penalty based. So we will have an experience of those kind of critical aspects and critical analysis of those provisions of the Companies Act. So first of all, when you look at decriminalization of the Companies Act, it is with reference to two things which are very important. The Companies Amendment Act 2019, which we have already taken a view, more than 50 provisions have become decriminalized, and the next is the Companies Amendment Bill 2020, which is pending. Lok Sabha has already cleared it, and which is pending for the approval of Rajya Sabha. Now, my dear friends, when you read the provisions, the clauses of this bill, you will find the critical analysis of the thought process of the Ministry of Corporate Affairs. What is this thinking? Now, second thing, which is very important for the business houses, at one point of time we were talking about MSME. At one point of time we were discussing about ease doing of business in India. So why these criminal provisions? When you compared Companies Act 1956 with Companies Act 2013, so many private companies were placed at the same platform where the public companies would have. So this is something very important to understand, that what the Ministry of Corporate Affairs is just thinking to give a better platform to the global business houses, and with the open arms we can just welcome our corporates to have sort of a investment in our country. So our law should be in line with the global laws, be it UK, be it USA, Australia, Singapore, wherever. So compliance should be tight, but it should be somewhere, should not be amounted to a criminal action actually at all. Section 447, for example, is really peculiar. It's really important, where fraud first time has been there. So ministry has already done a marvelous work, and it has also introduced a department SFIO. SFIO was not there in Companies Act 1956. Now Companies Act 2013 has provided it. So SFIO is doing his work, and it is in line with other departments like ED, CBI, Income Tax Department, Ministry of Corporate Affairs, Register of Companies, or the recent director. SFIO has been working hard, and this is something one has to understand when they have to understand the critical aspects of the Companies Act 2013, or critical analysis of the Companies Act 2013. My dear friends, when you say that what is decriminalization of Companies Act, oh, big question mark on that. A criminal offense which lead to imprisonment in the event of conviction, while a civil offense attracts a penalty. So whenever there is an offense after any provision, when you don't comply that, so there is a penalty which has to be there, and there is a imprisonment. So there is a conjunction between these two, or and. If and is there, then this is non-compoundable, and there is no decriminalization has been proposed by the ministry for those categories of offenses. But where or has been mentioned, then we can just have some sort of a liberty or leverage to be given to the stakeholders, my dear friends. So criminal corporate sanctions, civil corporate sanctions, and to maintain the healthy balance between these two. This is the objective of the ministry to have a more focused, decriminalized, face of the corporate in India. Actually, my dear friends, the objective of this is really clear from the ministry side. It will facilitate the ease of doing business. Very correct. At one hand, we are expecting a great FDI flow to our country. At the same time, we are apprehending that the foreign directors may be just caught under the umbrella of that criminal action. Why not to give that, liberty to the stakeholders by providing certain provisions has to be now decriminalized. Now it will reduce the burden on company courts. My dear friends, company courts like NCLT or maybe the company courts or the civil courts are flooded with a lot of litigations with regard to the compoundable offenses. Why not this power be delegated to some adjudicating authority like ROC? Section 206 is such a powerful section in the Companies Act which gives ample power to the register of companies and the recent directors as a head of that fraternity just to overlook those non-compliances and to just penalize those companies in case of non-compliances. So it will really reduce the burden on the company's courts. It will also ensure investor interest. So domestic investors or the foreign offshore investors, it will definitely increase that. Yes, a friendly atmosphere in the corporate entities in terms of regulators framework or the compliances in India is there. So in that way, it will ensure investor interest, my dear friends. My dear friends, lesser penalties for certain offenses. My dear friends, the quantum, when you look at the Companies Amendment Bill 2020, you will find the where the penalty was 5 lakhs, it has drastically reduced to 50,000. Where the 5,000 per day for the director penalty was imposed, now it has been suggested to 1,000. What is it? It is something lesser penalties for the certain offenses. So we will cover it in my later slides and you will definitely appreciate it. Instill confidence in both domestic and global players, my dear friends. As a stakeholder, as a professional, I also find it difficult when my one of the foreign client is attracting that sort of a criminal liability actually. So please just have a balance, instill confidence in the domestic and the foreign or global players in terms of carrying out business activities in India. It will boost foreign investment. It decriminalizing technical and minor non-compliances while retaining strict criminal enforcement to serious fraudulent offenses that jeopardize and prejudice public interest. Post IBC, after insolvency and bankruptcy court, we have all witnessed that how banks have come out to, realize their money from the corporates. This is something the government has to focus. Government is not required to focus that ABC Private Limited has not filed its balance sheet for last 1 year or 2 years. If they are not filed, please close it down. When they want to take the benefit on the scheme, please take them as an active company. And the government is not concerned about the penalty a private limited company can have to, be active company. So they are now more focused on big scams actually. And SFIO as a department, as a part of the companies in 2013 are doing wonderful job. NCLTs are doing wonderful job. But when you compare, number two, reducing the burden on company courts, and this one, you will find a lot of, painkillers actually in the legal fraternity. So it will recategorize the offenses which are in the category of compoundable offenses to an in-house adjudication framework. In-house, when I call in-house, so ROC will now give more powers to adjudicate the non-compliances. My dear friends, this is the technology time. Ministry of Company Affairs must be working hard in applying its mind and resources to introduce artificial intelligence in the system. Therefore, artificial intelligence will create a lot of in-house analysis of the non-compliances. They will issue a lot of notices. Notices shall be replied online and it shall be adjudicated online. What a fantastic system would be. So for that system to settle down, now provide that opportunity like CFS 2020 is providing you. For example, now decriminalizing certain offenses is just providing. My dear friends, by this way, the greater accountability with respect to filing documents will be on the shoulder of you, me, and other business houses or the stakeholder. We will be more focused actually in terms of timely compliances of the provision of the Companies Act. It will also enlarge the jurisdiction of regional directors by enhancing the penalty or pecuniary limits up to which they can compound offences under Section 441 of the Companies Act. My dear friends, when you look at the recent decisions of the Ministry of Corporate Affairs, you must be aware that the monetary limit to penalize to get the compounding done by the regional director office has become effective from 5 lakhs to 25 lakhs. So what a monetary jump from 5 lakhs to 25 lakhs. For example, if regional director can just come up with the adjudicating process, why we need courts then? Why to approach the court? Why to waste time of the honorable NCLT? Let them concentrate on IBC matters. Let them concentrate on other mismanagement and other important matters. Let them, concentrate on some summary trial or maybe summary suits. So this is the thing which, as a stakeholder, as a professional, I should, take in to consideration and, should concentrate actually. So this is the birth of decriminalization. This after this objective actually, the Company Law Committee, this is CLC, has set up by the which was set up by the ministry, has submitted this report to the MCA recommending decriminalization of around 46 sections which were compoundable offenses under the Companies Act. Now they are no more compoundable. Direct adjudicating those offenses will be done by the Office of Registrar of Companies or the regional director. So this list is in addition to the 16 compoundable offenses which were already decriminalized in the year 2019. So it becomes a list of more than 60. So this is something very important when you look at the provision of the Companies Act 2013. Now, my dear friends, the Companies Amendment 2019, which already provided this, which I just report you, this report of committee to review the offenses under the Companies Act 2013, post this amendment, which decriminalized 16 section of the act to civil violations only. It means they were not criminal in nature, they were civil violation. Treating them as civil violations, the adjudicating powers were activated of the Registrar of Companies to the next level under the provision of 206 of the Companies Act. Now, 2019 Amendment Act has also eliminated the criminal and criminality of these violations by levying some monetary penalties instead of criminal fines. So fine and penalty is very technical words you have to understand. Fine is associated with the penalty, compounding and compoundable offenses. Now the word fine has been substituted by what? The penalty. So penalty may be a monetary only. You just charge me some penalty. I am ready to pay, but no criminal action, no imprisonment. So when you look at the provisions of the Companies Act, you will find fine or imprisonment, fine and imprisonment. So wherever this thing has been provided to the stakeholder, fine has been substituted by penalty. Now, though these amendments were initially brought in by the Companies Amendment Act 2018, ordinance was there post 2019, and now the Companies Amendment Bill 2020 also provides this. Now, my dear friends, when you understand the articulated way of understanding of CLC's performance and CLC objectivity, you will find that it has categorized all the compoundable offenses in 8 categories as under. You have to understand why, because sometimes you have to narrate before your clients, you have to understand for your benefit, and technically speaking, for the purpose of just presenting some application or penalty, some application or petition before the regulator. So category A provides in non-compliance of orders of authorities such as NCLT or ROC. Category B provides defaults in respect of maintenance of certain records in the registered office of the company. Category C provides default on account of non-disclosure of interest of persons to the company which vitiate the record of the company. Category D, defaults related to the certain corporate governance norms. Category E is technical defaults related to intimation of certain information by filing forms with the ROC or in sending notices to the stakeholders. Category F, substantial violations that may affect the going concern value of the company or are contrary to larger public interest or with some serious implication to the stakeholders. Category G, defaults which are involving the liquidation processings. Category H, defaults not specifically punishable under any provision, but which are made punishable through an omnibus clauses. So these are the categories the ministry has thought of and then provided a line of confirmation to decriminalize the process of and the provisions of the Companies Act, my dear friends. Now, CLC has also adopted in principle and in principle based approach to decriminalization of offenses as under principle number 1. 23 offenses first. They are minor, very minor, less serious, compliance issue, and which can be objectively determined. Now it will be transferred to internal adjudication mechanism provided under section 454 of the Act, that is a reason directive power. Principle 2. 7 offenses that can be appropriately dealt with under the provisions of law will be omitted from the Act. So no at all criminal action. Principle 3. 11 sections or 11 offenses which do not fit into 1 and 2 above, the CLC has provided an alternative methodology of imposing sanctions. Principle 4. 5 offenses that involve substantiated and subjective determination but are not very serious violation will be punishable with fine only. That's simple. Principle 5. For 20 serious offenses that may be involving element of substantive non-compliance requiring detailed adjudication, the CLC has recommended no change. It means they will become intact. They will remain intact in the Companies Act as far as their adjudication, their criminal action is concerned. The CLC recommendation is also important that it has recategorized 16 out of 81 compoundable offenses under the Act to an in-house adjudication. Now ROC will get power under this, wherein defaults would be subject to a penalty levied by adjudicating officers. No recategorization of non-compoundable offenses under the Act. So the ministry has not touched any of the recategorization or decriminalization of any non-compoundable offense under this. Instituting a transparent, technology-driven in-house adjudication mechanism by minimizing the physical interface, conducting proceedings or an online platform, and publishing orders on the website. It will necessitate a concomitant order for making good the default at the time of levying the penalty to further the ultimate aim of achieving better compliance. Declogging the National Company Law Tribunal by enhancing the limit, that is the jurisdiction limit of the regional director to compound offenses up to the pecuniary limit of 25 lakhs. So declogging means few of the powers of NCLT has been delegated to which? To the RD. For example, declogging, when you convert a company from public company to a private company, approval of NCLT was required. Now no more approval of the NCLT. It has been declogged. Now RD can take care of this, and RD will give consent for the purpose of this power from NCLT to RD for the conversion of public company to a private company. Now, these are the categories of offenses under the Companies Act. Offenses attracting only civil liability, compoundable offenses which are punishable with the fine only or punishable with fine or imprisonment or both under the Act, non-compoundable offenses, offenses which are punishable with only imprisonment or a fine and imprisonment. Now, my dear friends, these are the principles which I have already covered. Based on that, look at the sections, my dear friends. Each section, please go through with me. Why? Because it's really important to know about this section, and you will, have an idea that what change this critical analysis will provide you actually. Section 10A, which is required to be followed when failure to furnish declaration under the section was there. So initially, penal provision as per the erstwhile section, no such provision was there. But penal provision as per the ordinance or you may say now the Companies Act. You may read ordinance as a act actually. So company now 50,000, an officer in default 1,000 for each day to maximum rupees 1 lakh. 53 section, which is relating to the issue of shares at a discount. Initially, company was attracting a minimum fine. The word is fine. Please take it of rupees 1 lakh. Maximum was rupees 5 lakhs. An officer in default, they were attracting a fine of rupees 1 lakh and maximum fine of rupees 5 lakhs. What changes there? Now, company and officer in default amount raised or rupees 5 lakhs and shall also be required to refund the money raised through such issue at a rate of interest of 12% per annum from the date of issue of shares. Section 64 relating to the non-filing of notice with the registrar of companies for the alteration of share capital of the company. Initially, the penal provision of erstwhile section was company and officer in default, minimum fine 1,000 per day, maximum fine was 5 lakhs. Now, company and officer in default, minimum penalty is there. Fine has been, replaced by penalty of rupees 1,000 per day, right? So this is important. Now, section 19, with regard to the persons who fails to make a declaration, no such provision was there. Now, imprisonment of 1 year or with the fine applicable and may even be levied fine and imprisonment both. 92 section non-filing of annual return, company minimum fine 50,000, maximum was 5 lakhs. Officer in default was also there. Now it has been replaced by penalty, not fine. So you may just have it. This is important. This is important. So you can just have it. The fine has been replaced by penalty. Section 102, misstatement in the explanatory statement. Same. The amount remains the same, but the fine replaces by penalty. Section 105, with regard to the notice of general meeting to contain clauses for proxies, it is also replaced by penalty. Non-filing of MGD 14, really important section. And company minimum fine was 1 lakh, maximum fine of rupees 25 lakhs. Officer in default, minimum fine of rupees 50,000, maximum fine of rupees 5 lakhs. So company now minimum penalty of rupees 1 lakh, or further penalty of rupees 500 every day, maximum of rupees 25 lakhs. An officer in default, maximum penalty of 50,000, further penalty of 500 per day, and maximum penalty will reach to 5 lakhs. So now here fine, which was compoundable, has been given to the sort of companies for adjudication purposes, and penalty has been replaced by the word fine has been replaced by the word penalty. Non-filing of MGD 14, likewise, the word fine has been substituted by the penalty. Section 137, very important section, my dear friends. It is for the purpose of failure in filing financial statements with the rest of companies. If you recall, just in 2019, 18-19, when the non-filing of your balance sheet or annual return. So these two sections were really important, section 92 and section 137, for the purpose of filing your annual return and your balance sheet. When you fail to file it within the stipulated time, after the stipulated time, this will cost you 100 rupees per day. When in the first year you have not filed it, second year starts, then it will, or consecutively second year you also don't file it within the stipulated time, then the penalty will double, and then 200 per day. It was just really pathetic to face that sort of a penalty, because as a stakeholder, I cannot afford to pay mere 40,000, 50,000 per e-form on that filing actually. So therefore, this adjudication power now becomes effective. Non-filing of e-form of 883. Now 883 is really important for the auditors. Now here I can take it a listed company or a non-listed company. So when listed company file 883, simultaneously this intimation has to go to SEBI, and SEBI asks the reason from the auditor to take it in principle, that what is the reason they have given their they have given their resignation letter. Ministry also, the ROC has also issued so many notices to the this auditor. So here I want to share one notice recently become part of the came and question where one auditor has filed his ADD3 for the purpose of some company. ROC has asked why you want to just resign. Auditors say, oh, I'm preoccupied. So ROC asks further, just show me your occupations, how many companies you have been auditing actually, is there any new audit, why you don't want to just continue as the auditor of the company. So these are the questions actually which will now increase the volume of intensity from the Office of Registrar of Companies as a power which has been given to them as a adjudicating authority, my dear friends. So next is section 159 is also punishable for the contravention of section 152, 155 and 156. When you look at imprisonment of 6 months has been deleted and fine has been replaced by penalty. Now non-compliance of permissible number of directorship by director. So this was initially minimum fine 5,000 was there, maximum fine of rupees 25,000 was there. So now penalty is only rupees 5,000 per day, my dear friends. Now contravention of section 191, it relates to director again, and you can see that this penalty has been now settled at rupees 1 lakh only, and it is now a penalty, not a fine. So these are few sections, my dear friends. Section 197, 203, relating to default in the appointment of key managerial personnel, contravention of the registration of offense or offer of scheme of involving transfer of shares. There are few sections which one may just have it. So here from me actually this is section 447 is also, which is related to the penal provision for fraud involving rupees 10 lakhs or 1% of turnover and does not involve public interest. So one has to really look at these provisions, how decriminalization process has been there. 159, 165, 191 again. So these are the sections actually. So this is the highlights now I want to share of the Companies Amendment Bill 2020. My dear friends, the Companies Amendment Bill 2020 was approved by the cabinet, and it has been introduced in the Lok Sabha on March 17, 2020. Over the past year, this bill has been the second attempt by the Ministry of Corporate Affairs to decriminalize offences under the Companies Act 2013, the first being the passing of the Companies Act 2019. So here, these are the sections, further sections, which have been now suggested over here. Section 16, rectification of name. So if a company was registered inadvertently with a registered trademark of a proprietor, and the name is too identical or resemble on existing trademark, such company has to change its name within 3 months from the issue of central government approval or direction, instead of 6 months timeline provided earlier. So now this 3 months period has been there as a rule. Section 62, regarding further issue of shares, that is the right issue, proposed to lay down such other time period which may be less than the timelines prescribed currently. So when you connect this section, connect this with section 73 of deposit, where rule 2 for section 73 provides that within 60 days of collecting the money, you have to allot the share capital. Section 117, resolution agreements to be filed, MGD 14, which is really important. So it currently exempt banking companies which are providing loan, guarantee, security in connection with loan in its ordinary course of business from filing the resolution in e-form MGD 14. Now it has been now proposed to extend such exemption to registered NBFC and HFC as well. Section 129A, this is a periodical financial statement. It will be newly inserted. The central government shall undertake such class or classes of companies to prepare periodical financial results, obtain approval of board of directors, complete limited review of such periodical financial results, file a copy with the ROC within 30 days of completion of the relevant period. So wait for the time when maybe unlisted companies required to file their quarterly or 6 monthly statement with the Ministry of Corporate Affairs under this newly suggested 129A. Section 135, this is related to CSR. So the change which are proposed over here, the amount is spent in excess of requirement may be allowed for setting off for such number of subsequent financial year as may be prescribed. To share with you, some of the foreign company as a global policy invest more than 2% of their average profit. So when my foreign company provides 4%, so I'm just required to have 2%, and next year I can just set it off, or on every officer default 1/10 of the amount required to be transferred in the respective funds of rupees 2 lakh, whichever is lower. So certain limits has been just provided under this section 135. Now no requirement would be there in terms of CSR committee where the amount required to be spent is more less than rupees 50 lakhs, and the board of directors shall discharge the functions of that of section CSR committee. When you look at section 134 subsection 3 clause O, you will realize that one committee was to be formed. That committee will design the policy. That policy would be there, and that policy will take its birth from schedule 7. They will just sort it out what avenue is there where they can just have an expense of their CSR fund. So this now has been delegated to the in-house directors. There is no need to form a committee where this amount is not more than 50 lakhs. Section 149, company to have board of directors, independent directors. That's simple. So an independent director may receive any other sort of remuneration excluding the aforesaid in terms of schedule 5, wherein there is no profit or inadequate profit in the company. Section 197, which categorically required overall maximum managerial remuneration and managerial remuneration in case of absence of inadequacy of profits. So this section has been aligned with section 1499 when you look at that section to include non-executive directors and independent director within that time frame ambit of remuneration payable as per schedule 5 in case of no profit or inadequate profits. My dear friends, thank you so much for this deliberation. I can take any question of you, if any. Deepak ji, over to you. If any question is there, we can take it actually.
Thank you, Deepak ji, for having excellent deliberation on the topic of the CFSS. You have, taken all the aspects which are relevant in current time and given very detailed overview of the company fresh startup scheme and LLP fresh startup scheme. Now, issue at my end. Now it's working. So now, and also I request all the participants kindly like this video and share this video. Also, please provide the feedback. How was the presentation? I can see the few comments are still started coming. Good practical session, great presentation. Still, those who are 73 people are present here. My humble request to all of you is to provide your feedback about the session. Now, let me go back with the queries. I can ask the queries now. So this is first query in front of your screen. Can we verify from MC side what are pending forms to be filed for a company?
Question is really related to what I requested you at the starting of my session, that for your clients, for your company, first please have a due diligence, internal due diligence, or sort of a own verification. When you file forms with the Ministry of Corporate Affairs, you file two types of forms: event based and non-event based. When event based forms are there, so these forms are connected to some corporate action. Like for example, financial statement filing or annual return filing, you get a lot of notices from the ministry side that you have not filed it. So that mechanism is there. You will receive that. But for the purpose of compliance, for example, section 117 is very peculiar. If you have made certain investment, how MC will come to know about that? So this is sort of a combination of both. So it is really good for you to understand the way how to conduct the internal due diligence processes. Please go through each and everything. Just go through the document, the financial statements, the corporate action, their minute book, discuss with their key personals, key manager personals, what they have done during these times from the date of incorporation of the company, and you will find a lot of non-compliances. There are certain event-based forms, like for example, active form was there, KYC is there if they have not completed, and most important, through this forum of Study Cafe, I'm just sharing with you, MGD 14 is a really common form which most of us would have forgotten. So please verify whether you are covered under section 117, read with section 179 or some other section like one section 185 and 186. Deepak ji, over to you.
Yes, sir. So second question is, which is in front of your screen as well. Can a company strike off in bulk striking off or revive after filing all pending returns through this CFS screen 2020?
A company which has been striked off has been categorized into two. When you have voluntarily applied for, you cannot opt this CFS 2020. A company which has already been become a CF, striked off by two methodologies. One, the MCA has closed it. Two, you have closed it. When you have closes, you may not. When government has closes, you may not. But there is one way out. Please approach the Honorable NCLT under Section 45, 2 of the Companies Act to get the revival. Why you want to revive? Some business may be there. So NCLT will not mind under the CFS 2020 era to provide you that, preposition actually. You commit before the NCLT, I am here, I want to revive my company, I have a business plan, solid business plan I can present before you, and please revive me, and I want to just take the benefit, and I, pay all the, existing, whatever the fees is, and I comply all the, forms, and I clean the slate under this CFS. I think there is no reason why NCLT will not provide you that sort of everybody. So for strike off companies, yes, you can apply, but before that, please apply before the NCLT to get it revived.
Okay. So one question is also there on my mobile. If a company wants to do its filing and both the directors are disqualified, so I heard that there is a view, some option of going, back end way of asking MCA to add some other directors, two additional directors, and then they can do the compliances. So how that process can be done? We need to give the application to the MCA, and is it possible now because this scheme is till 30th September? So MCA will be busy. So will they provide approval within 2 months to add these two directors?
See, Deepak ji, this question is really good question, and answer also lies in my presentation. When you look at a company, for example, what this gentleman want to ask, this company must be a company, only two directors, and both of them are disqualified. You cannot
Yes.
approach the Honorable High Court for the purpose of their removal of disqualification. Now, what you can do? Now, this modus operandi was earlier were also applicable. Now you can appoint one, authority to file it. Like for example, you can just from the back end, because as a shareholder now under section 167 subsection 3, promoters are allowed to induct directors from the back end. So here it is a power of section 167 which give you that liberty from the very initial stage. So under section 167, you approach the register of companies with all the shareholder meeting. You hold the shareholder meeting, approve certain person to be designated as director from the back end, request the ROC that from the back end, please enroll him as a director of the company so that his digital signature can be used for the purpose of taking the benefit under the CFSS 2020. Sorry. Now ROC will process the application with the consent of the regional director. So here is the power which has been vested with the regional director, which will give its way to the ROC. RD will ask the ROC whether any litigation, whether any non-compliance, when any illegal, whether the existing two directors which who have become disqualified are trapped under any EDs, say CBI or other scanners. So there are a lot of internal guidelines which govern. But yes, today if you decide to depute someone else actually from the back end, it will take not more than 30 days to be able to induct those directors from the back end. Take the benefit, file out the pendency. And one more thing I want to share you, Deepak ji, the new person who shall be inducted by this way, he shall not be disqualified because of that existing non-compliance, for the purpose of that non-compliance for initial 6 months time. So this is a good way actually to take the benefit under this CFSS 2020.
Yes. This I think you have already replied. It is applicable on which kind of companies. This you
This
have
is
already.
applicable for all kind of companies except few companies like under Studycafe or amalgamated companies are not covered in that.
I think left out forms can be filed under this scheme. Next question is in
Yes,
front of
why
the
not?
screen.
Why not? Please, you can. और आप जो भी फॉर्म्स हैं आपके, जितने भी फॉर्म्स हैं वो 70 जो 2 फॉर्म्स हैं उसकी कैटेगरी में आने चाहिए. मैंने आपको एक चार्ट दिखाया था जिसमें अगर अभी स्क्रीन पे देख पाए, मैं एक स्क्रीन शेयर हो रही है अभी.
Yes, yes, yes. For you.
देखिए, इसको देखिए आप, ये एनुअल फाइलिंग रिलेटेड फॉर्म्स हैं, रेजोल्यूशन रिलेटेड फॉर्म्स हैं, डायरेक्टर से रिलेटेड फॉर्म्स हैं, आईपीएफ के फॉर्म्स हैं, ऑडिटर से रिलेटेड फॉर्म्स हैं, फॉरेन कंपनी से रिलेटेड फॉर्म्स हैं. आप ये सारे फॉर्म्स जितने भी पेंडिंग है ये आप फाइल कर सकते हैं. एमसी साइट पे जब जाते हैं mca.gov.in, तो आपको फर्स्ट पेज पर ही उन फॉर्म्स की लिस्ट मिलेगी. आप उसको क्लिक करिए, देखिए कौन सा फॉर्म छूटा हुआ है, आप फाइल कर सकते हैं. इवन अगर आपका 1980, 1985, 1990, 1992, 2000 उस साल का भी कुछ फॉर्म छूटा हुआ है, वो उस कैटेगरी में आता है. नॉर्मल फीस दीजिए और फाइल कर दीजिए इस फॉर्म को.
Yes. Next question is there any option while filing the e-forms that I will apply later for CFS? Later का तो सर कोई I think option नहीं है.
दीपक जी इसमें कोई लेटर का कोई ऑप्शन नहीं है. आपको 30 सितंबर तक फाइल करने हैं अपने फॉर्म्स और 1 अक्टूबर से 31 मार्च तक इम्यूनिटी सर्टिफिकेट के लिए CFSS 2020 फॉर्म फाइल करना है. दैट्स सिंपल.
Okay. If an LLP failed to file the initial agreement, can it be done under this scheme?
100% yes.
Next question, Mr. Sushil Sharma is asking. LLP was incorporated in April 2019. Only bank account is opened by initial contribution of the partners. No other transaction is done for 1920. No business in LLP. Should we have to follow all filing? Obviously, filing तो सर MCA में अगर आपने कंपनी या LLP बना लिया है तो चाहे आप काम करें या ना करें, मतलब अगर कंपनी LLP बनाने से पहले वो सोच लीजिए कि कंप्लायंसेस कर सकते हैं तो ही आप बनाइए, अदरवाइज पार्टनरशिप हम बना लीजिए.
हाँ, इसमें सुशील जी इसमें जो भी आपने चाहे वो आपके फाइनेंशियल स्टेटमेंट्स हैं, आपके इंटीमेशंस हैं, रजिस्टर्ड ऑफिस की डिटेल्स हैं, एग्रीमेंट्स हैं, वो आपको फाइल करने हैं.
सर नील के भी आपको फाइल करने पड़ेंगे. और अगर DIR, अगर आप ये बोलते हैं सुशील जी कि पूरे साल कोई बिजनेस नहीं हुआ या नेक्स्ट ईयर भी कोई बिजनेस नहीं हुआ सपोज, तो नेक्स्ट ईयर भी आपको जो मिनिमम जो कंप्लायंसेस है फाइनेंशियल्स फाइल करने पड़ेंगे, KYC के कंप्लायंसेस करने पड़ेंगे, अदरवाइज आप डिस्क्वालीफाइड हो जाएंगे अगर KYC भी नहीं करते हैं. सो इन केस इफ यू थिंक कि आपको कंप्लायंसेस नहीं करने हैं तो आई वुड सजेस्ट कि गो फॉर द पार्टनरशिप फॉर्म, LLP या कंपनी फॉर्म मत कीजिए. This we have already discussed. Vicky Gadaji is asking, in case of the private company with 2 shareholder, husband and wife, one of them dies, then what is the procedure for share transfer? Who will be the shareholder?
I think, Vicky ji, this is a other way question, but I will reply. The shares can be transmitted as per the succession rule. If those shares are to be devolved, in your son or daughter, whatever way, that has to be there actually, right? So this is there is no automatic way of transferring the shares. The shares shall be transmitted. The existing shareholders, whosoever is this, So they will just take on record. And from the point of view of the inducting more directors, you can take both options, maybe from the back end, maybe by having the shareholder meeting. Actually, you can have it actually.
So if you participate have feedback link, feedback you can provide in the comment box. Your comments we will take it as a feedback. You can give your feedback. Now there are few comments are coming. Sir, these are for you. Great presentation, informative. Thank you very much.
Thank you so much.
Pradeep Kumar ji
Deepak,
asking where CF. Yes, sir.
ji, ji. Yeah, please carry on.
Whether CFSS can be availed for current year forms. What is the last date for which forms can be filed in case of the LLP?
See,
Current year.
करंट ईयर तो आप वैसे भी आपके पास टाइम है पूरा, आप कर
हाँ,
सकते हैं।
so
और प्रिंसिपली स्पीकिंग 31 मार्च को क्योंकि ये हुआ एक्टिवेट और 1 अप्रैल से एक्टिवेट हो गया, तो प्रिंसिपली स्पीकिंग जो भी 1 अप्रैल से पहले के फॉर्म्स थे पेंडिंग, वो इस स्कीम के अंदर कवर हो जाएंगे।
yes. So these are the few comments we have received. Great presentation, Deepak ji, Pradeep ji saying excellent, good presentation. Deliberation were very. So friends, if you still have questions, whatever questions came, we have taken all the questions. I request you kindly ask your questions which are pending. If you have any further questions, you can ask your questions, and please give the review as well, and like this video and subscribe our channel as well. And if you have any other queries, we still have 5-7 minutes. So Deepak ji is still here. He will reply for your queries. Let me see if there is any other queries coming again. This video will be available on the YouTube. You can watch it later on as well if you want to understand anything. We can take your queries again. If there is any query, we can check. How system will know not to charge additional fees?
The internal system of the MCA, Deepak ji, it has been customized in a way. The form, the related e-form has a unique nature of giving some details of the dates and the event on which based actually the system will evaluate whether additional fees will be charged or not.
So for a layman, just asking one thing. In this case, let's suppose if I am doing compliances for my earlier forms which I have not filed, let's say for 17-18. So when I make the payment, so do I need to? There is a drop down whether it is deliberately asking under CFSS, or if I normally
No,
pay, then
it's a
also
normally paid.
normally pay, then also
It's a
fees is not coming.
हाँ दीपक जी, फॉर द बेनिफिट ऑफ अदर आल्सो, फॉर्म के अंदर कोई चेंज नहीं किया गया है, कोई
Okay.
चेंज नहीं किया गया, बस केवल सिस्टम के अंदर कर दिया गया है। जब एसआरएन जनरेट होता है तो वो एसआरएन जेट जब जनरेट होगा तो वो किस फीस के साथ होगा उसमें चेंज आ गया है केवल।
Okay.
तो आपकी केवल
Okay.
नॉर्मल फीस आएगी, एडिशनल नहीं आएगी, लेकिन उसके नीचे आपका कुछ लिखा हुआ आएगा। वो क्या लिखा हुआ आएगा? इट इज सब्जेक्ट टू योर सीएफएसएस इम्यूनिटी सर्टिफिकेट, क्योंकि इसी एसआरएन को आपको 1 अक्टूबर के बाद यूज करना है सीएफएसएस का सर्टिफिकेट लेने के लिए। तो ये भी आपके लिए इंपॉर्टेंट है। आपने फॉर्म तो फाइल कर लिए, लेकिन आपने CFS 2020 फॉर्म फाइल नहीं किया, तो आपको इम्यूनिटी नहीं मिलेगी, आपको बाद में प्रोसिक्यूट किया जा सकता है और आपसे एडिशनल फीस चार्ज की जा सकती है।
So friends, very important information Deepak ji has shared. Once we have done our compliances till 30th September, after that we definitely have to go for the immunity scheme, which is valid till 31st March 2021. Sir, पहले भी कुछ participants were asking whether if they are not able to file 31st March, or is this date is going to extend. So I don't think so. 31st March 2020 one date is going to extend, and we need to file for immunity within this time only.
I think Deepak ji, we should strive to 30th September. We should not target anything. 2 months are there, and up to 30th September, there is no annual filing sort of a burden on us also as an unlisted
Yes.
company. Because
Yes,
when you basically see this CFSS is basically in majority cases for the purpose of unlisted entities, not the listed entities. Because listed entities in any case would have complied there, except few.
Yes.
So for unlisted companies, there is no major event till 30th September. You can find time. Okay, we can always seek more permission. So I hope that ministry in this pandemic time may extend further. But this is not a expectation from me.
Expectation.
This is expectation of all the buses.
And one more question came from the Jatin Bajarji. A company created in Jan 2019 and not filed any return till now. Can it file its return without late fees? What is the procedure we have to follow?
फर्स्ट ऑफ ऑल, अगर आपने इसमें जतिन जी कोई काम नहीं किया है, तो सबसे पहले आपका जो फर्स्ट फाइनेंशियल ईयर है वो 31 मार्च 2020 होगा।
20 ही
आपका
होगा।
31,
15
हाँ 31 मार्च, यस
15
2020।
मंथ्स का
तो
15 मंथ्स का बेनिफिट भी ले लेंगे ना सर, ये शायद
वो 50 मंथ्स का बेनिफिट भी ले लेंगे। एंड आपका ये जो भी टाइम होगा, इसको आपको रखना है कि आप 31 मार्च 2020 से अगर बैलेंस शीट और एनुअल रिटर्न को आप फाइल करेंगे, तो मुझे नहीं लगता कि आपकी कोई भी पेंडिंग फॉर्म बचा हुआ है, क्योंकि ना तो आपको ऑडिटर को अपॉइंट करने के लिए उस टाइम एडीटी 1 फाइल करना था,
Yes.
बिकॉज फर्स्ट ऑडिटर के लिए आपको एडीटी 1 फाइल नहीं करना है। हाँ,
not required.
अगर इन बिटवीन आपने कोई डायरेक्टर इंडक्ट कर लिया है, या कोई और आपका लाइक आपने INC 22A फाइल नहीं किया, या आपने केवाईसी नहीं कराया डायरेक्टर का, वो आप इसमें भी करा सकते हैं। इस स्कीम वो ले सकते हैं।
ग्रेट सर। सो आई थिंक अगर ये इन्होंने 1920 के फाइल कर दिए होंगे, तो अगर 2021 में कुछ नहीं करा तो नहीं, Jan 19, so 18 19 में अगर if they have filed or they have done compliances, then only they can take the benefit, otherwise 15 months में जाके they can take the benefits, right sir?
दीपक जी, इसमें सेक्शन 2 सबसेक्शन
Sir, your voice is not
40
coming.
पर है कि अगर कंपनी, यस हेलो,
Yeah, now it's audible.
हेलो,
Yes sir, yes sir.
अगर कंपनी 1 जनवरी और 31 मार्च के बीच में बनी है, तो उसका फॉलोइंग ईयर जो होगा वो आपका फाइनेंशियल ईयर होगा। अगर इन्होंने अपना फर्स्ट फाइनेंशियल ईयर 31 मार्च 2019 ही बना दिया है और
हाँ।
अगर बैलेंस शीट फाइल नहीं की है, तो वो CFSS में कवर हो जाएगी दीपक जी।
कवर हो जाएगी, ठीक है सर। Ankit Jain is asking, DPT3 can be filed without late fees till 30th September?
एब्सोल्युटली यस, क्योंकि
Okay.
DPT1 DPT2 सारे फॉर्म्स इस CFSS में कवर हो रहे हैं।
Friends, if you still have any queries, you can ask your queries. I cannot see any further query. So my humble request is kindly like this video, so that we can get the feedback from all of you, because your appreciation is a feedback for us, and for a speaker as well, and for a organizer as well. We always request from all the participants, kindly give the feedback, whether it's positive or negative. If you think any things we need to improve it from speaker side as well as from the host side and organizer side, then also please let us know. We will try to improve it in our future webinars. And today I think we had very detailed discussion in CFSS scheme. Yeah, now you will not have any issue in that. Sir, would you like to share your number or email ID?
Yes, Deepak ji, this is there. I have screen to share.
Yes, screen is shared.
This is there. And
You
Deepak
can,
ji, I would also request you, as I always do, Deepak ji, Studycafe is doing wonderful job.
Thanks a lot, sir.
And
Thank
just
you,
as
sir.
just as a contributor, I can only request that the stakeholder who are the subscriber of your channel and of your this Studycafe, they can raise any query anytime to you, and you can just pass it on to me for
Sure.
appropriate reply in that.
So friends, still if you have any query, you can WhatsApp me as well on my number, and I will pass your query to Deepak ji. Sir, आपकी screen थोड़ा enlarge कर दीजिए, so that participants can see your number or email ID. It is not enlarged. Full screen कर दीजिए एक बार. Yes, now it's visible. So you can have the email ID and phone number of Deepak ji. If you have any queries, you can WhatsApp him or call him, and you have the email ID of Deepak ji as well. It's sjacorporate@gmail.com. You can ask your queries from there as well. Now also we are still getting the comments, informative section. Great session. So thanks a lot, everyone. Thank you all the participants. Because of all the participants, we are conducting these sessions. Because for a webinar, participants are the lifeline for us. So since you guys are coming, so we keep on inviting all the renowned faculties for deliberation, so that we can enhance our knowledge on the subject matters. And I once again thank you, Deepak ji, for taking such excellent session. 2 hours, sir,
Thank you
you
so
keep on talking, and you were speaking on very high energy. So I once again humbly thank you for being here. And with
Thank
my
you.
one request, you accepted my invitation and taken this session. Once again, thank you from bottom of my heart. And in future also, will we keep inviting you to have sessions. Probably when we
My
have
pleasure.
annual filing. Before that, we can have few more sessions on company act as well. Thanks a lot, sir. Thank you very
Thank you
much.
so much. Thank you so much, Deepak ji. Thank you.
Thank you, sir.
Thank you.
Thank you, friends. And now, two, three information. Let me just share quickly with you. We are coming up with the one Excel certification course. Link of the same had been given in the description. I will take that Excel certification course, and this is going to start from 25th of this month, and then from 1st August we will have training session on GST, GSTR 9, practical written filing. That also you can join, and the stock market 5-day certification course also we are planning to start. That link also will be given in the description. That also you can join. This was the information I wanted to share. Thank you very much.